big issue I want to discuss with you, we have had a fascinating discussion, is about conspiracy 120B. Now, in every offense where you do not have direct evidence against an individual, you add 120B. Now, that man will never get bail. There is no proof of conspiracy till the end of the trial. Now, what happens to that category of cases and those accused who are involved in the 120B? Should 120B be used in this fashion under a criminal
jurisprudence? That's the point. First of all, it has been around, but the misuse and the use in which it is done now was not being done earlier. That's the tragedy. Even with similar provisions, you are really misusing it now. Number two, in every case, I'm finding an argument which is completely used not to be raised earlier, that 120B is a standalone. 120B, the tail will wag the dog. It will stand alone. Now, there is fortunately, and these are the kind of things which are required, judgment which says that you cannot have a 120B alone under, for example, the PMLA. It's a very robust judgment. But even today, as of yesterday or day before, the argument is still continuing. It is justified. It is not, there are any number of cases I am doing where 120B as a standalone is justified. After a judgment, there has to be also, I think, somewhere a sense of responsibility by the people who still propound an individual case that, look, this is now covered, that should go.
You forget PMLA, 120B used in every
even in every other case also.
To get involved, to get people as accused, who they want.
I believe, I really hope that judgments like this are also made in the other non-PMLA category and they are consistent. My fear is always that you make the right thing and then somebody changes the law in another judgment shortly.
Again, in 120B, there should be some legal parameters on the basis of which you can involve somebody in conspiracy. What are your thoughts on that?
No, my thoughts are on your last comment. See, one thing is to lament that the court is doing this, court is not doing it. That's one issue.
Yes.
I mean, there's no point of lamenting beyond a point. You have to bring a structural change in 120B.
Yes.
It's a 150-year-old law.
Correct.
It is being used or misused or whatever. Just as we were discussing that the power of arrest or custody should be with the body apart from the police, some structural change should be brought in that provision because it's a all-encompassing provision.
Exactly.
120B, conspiracy, small conspiracy, big conspiracy, larger conspiracy, all these things are developed.
Exactly.
So you put in something in 120B, and if the legislature doesn't do it, the court should step in to say that the rigors of 120B will be tested on these
parameters.
कि भाई some prima facie material कि तुम उनसे मिले हुए थे.
Correct.
In some form or the other.
Correct.
And the classic test is a Privy Council test where some people robbed a bank. One guy was waiting in the car, the getaway car. He argued that, look, I didn't do the robbery, I was only driving the car. So they said, no, you are a part of the scheme and you were looking कि police na aa jaye, and therefore you will be a part of conspiracy because you were in the scheme. Now, the cases you were talking about, this man doesn't know what is going on there.
Exactly.
So unless there is some structuring, it's said by Privy Council 100 years ago. So you structure that through the court. It won't happen through Parliament. Structure it through the court. Take out the Privy Council judgment. Put your own imprimatur in whichever manner you want into it.
Mukul, I have seen cases ke kisi ne speech di Mumbai mein and some violence took place in Delhi. They will say, but he was the linchpin, the man who gave the speech in Mumbai, and he'll be involved in conspiracy. Well, I've seen this happening. And people are in jail for 3 years, 4 years for this kind of stuff. But this is a very serious issue. And the problem then, and the last issue before we close this wonderful discussion, is that why does the trial court never grant bail to anybody? But this is a very serious issue. As a matter of course, no magistrate will grant bail. In the rare case, maybe.
No, I'll tell you, Kapil,
this is a very serious issue.
Our experience shows that when we started practice, the High Court used to write a 5-line order and grant bail. Hearing would last 5 to 10 minutes.
That's right.
As things progressed, these laws became more complicated. And unfortunately, the Supreme Court, which was supposed to be the beacon of these freedoms, despite saying bail is the rule, not jail, etc., The Supreme Court, I am sorry to say, has become small-minded. A large number of bail orders are today interfered with,
Yes.
which was never the job of the Supreme Court even 25 years ago.
That's correct.
Every second bail order is interfered with. A grant of bail is stayed by the court.
That's correct.
That you remain in jail.
Yeah.
Normally, if you have bail, it can never be stayed. You
Absolutely.
can cancel it in egregious
Absolutely.
cases, but you never stay.
Absolutely.
But since that is now happening in a mundane fashion, routine fashion, that also filters down.
That's right.
I mean, High Court judges also say, if we grant bail, next day it is stayed, comments are made, why you granted bail? So it filters down, वहाँ bail नहीं मिलेगी, वहाँ cancel होगी, तो हम भी नहीं देंगे. Remarks are made, अरे साहब Supreme Court चले
the
जाइए.
mindset of the magistrate is कि भाई हम तो नहीं देंगे, आप हाई कोर्ट से ले आइए.
अब ये mindset High Court में भी है.
It's a very
और
strange
हाई कोर्ट
amalgam.
कहता है कि ये हम नहीं देंगे, आप सुप्रीम कोर्ट से ले
It's a
आइए.
very
ये सारा
strange
ऊपर से
amalgam.
filter होता है.
It's a strange amalgam, Kapil. I think there is also a feeling being generated. अगर इसने बेल दी है तो सब कुछ दाल में काला है.
हाँ,
ये भी
correct. That's the
वो
other
दाल
problem.
में काला theory goes then to the High Court. हम अपने ऊपर क्यों ले? Let the Supreme Court. That is one part. There is another part for special categories, and this is, I think, important in practical terms. For special categories, you have special judges. Now, it's okay. Special judges is valid. You must have special judges. You must fast track certain categories. But why should you have the same human being as special judge for years? Whether it
Because
is
he's special.
MP, MLA
Because he's a
courts.
special human being.
By MP, MLA court, you certainly have. But we are now finding a chain where trial judges are lasting
Yes.
2 years.
Yes.
There's no problem. Nobody is asking for a particular judge. You rotate the judges every 3 months. High court judges in that category are lasting 2 or 3 years. The net result is the chain of command is made straight away,
Yes.
where the result is virtually known because you know
very,
the particular. I'm not
Actually,
saying
Kapil,
anything
sorry.
bona fide or not, but it could
Yes,
be bona fide. But my predilection, even bona fide, makes a consistency of negativity right up to the Supreme Court.
That's right.
आपने mindset की बात करी. Till recently or even now, people used to say कि भाई bureaucracy का mindset कैसा है? कागजी कार्रवाई करते जाओ, decision मत लो,
Correct.
और ऊपर लिख दो submitted please.
That's
तो
correct.
फिर ऊपर गया, उसने कुछ लिखा, फिर उसने लिखा submitted please.
That's correct.
तो इस तरह जो चल रहा है वो ही यहाँ आ गया है. Submitted please, आप वहाँ चले जाओ.
Correct.
वो कह रहा है आप वहाँ चले जाओ. और ऊपर mindset अगर वो वैसा नहीं है, तो
It's a very,
this is actually.
Well, all that I can say is that we've touched the tip of the iceberg.
Absolutely.
There are so many very serious issues
Absolutely.
that bedevil the functioning of the criminal justice system. But thank you very much for being here, because this
Thanks
will,
a lot.
I hope people who listen to this understand, because we are here not for any personal issues. We are here for the larger interests of the country in the context of the freedoms that we cherish. And I hope that we are going to meet in future and have some
Thank
in-depth
you.
discussion on many of these issues.
Thank you
So
very much.